All right, good morning, everyone. Just wanting to check in, Cindy, Naomi, and Mary, that you're ready to go. Wonderful. Thank you for being here with us this morning, and thank you to everyone else who has joined for this really important conversation this morning. I want to ensure that we open up in a good way, and going to ask our elder, Deb Foxcroft, to open us up.
Good morning, everyone. Uklama. Deb Foxcroft. Quills is my traditional name. I wanted to just let you know that I'm coming here from Sešwk First Nation, my territory, and just wanted to acknowledge all of the beautiful lands and nations that are here joining us today on this very important work that it's been going on for a long time, and we're finally at a place of, doing the work on behalf of our children and youth our way. So I just wanted to hold up my hands to our panelists and to all of you that come here with open minds and open hearts, and to just come with a loving heart for on behalf of our children and youth and families, and that we go ahead in a good way today and into the future. We all know that this work is a sacred work, and we do it not for ourselves, but for our children, youth, and communities. So I, again, just acknowledge all of you for being here. I just wanted to say, Creator, Great Spirit, thank you for this day. I ask that you open our minds and our hearts, ground us in this sacred work that we have ahead of us, and that we work with those connections of strong minds, strong hearts, and our spirits acknowledge the ones that have been lost in the systems, and acknowledge any hurt and pain as we and I send out love and healing to everyone today that needs it in terms of this work. So again, just sending you just positive energy and strength to do this work. Kleko, all my relations, Chu. I do also want to acknowledge today is National Women's Day, and I just wanted to send out my prayers for all the women here, the strong matriarchs and women in leadership. Women have huge responsibilities, especially in child and family services. And I just wanted to acknowledge everyone, including our LGBTQ plus two-spirited folks. And I just wanted to say I'm just really honored to be here, and that today is a good day. Bye.
True. Thank you, Deb. I want to start off this morning just by raising my hands and acknowledging our expert panel this morning. Thank you so much for taking time out of your incredibly busy days and your schedule to be here to help navigate this conversation around the Supreme Court of Canada's recent decision relating to the Act respecting Indigenous children, youth, and families. And so just want to start off by introducing myself. My name is Jennifer Chukri. I'm joining today from the beautiful territories of the Tsleil Waututh people, specifically the village of Squamish. My family is Nika on my father's side, Norwegian and Swedish on my mom's. My father's people come from Treaty 4 territory in southern Saskatchewan. So grateful to be here. I work with the Our Children Our Way Society and joined the society in October of 2023. I work in the role as executive director after having spent the last 13 and a half years working for an urban Indigenous Child and Family Service agency here in British Columbia. So incredibly grateful for this new opportunity and journey that I find myself on. The Our Children Our Way Society represents the 24 Indigenous Child and Family Service agencies in British Columbia, and more recently have been working to expand our membership to include BC nations who are resuming their self-determination in the area of child and family services. And so always very grateful and humble for the work of the Our Children Our Way Society and the Secretariat team. Through our society and the Secretariat team, we advocate for systemic changes to policy, practice, legislation, and funding to safeguard the best interests of Indigenous children and youth. I too also just want to acknowledge that today is International Women's Day, and really just want to raise my hands to the incredible women who sit and share space with us today. I want to express my gratitude for your brilliant leadership and the sacred work that you do every day on behalf of Indigenous children, youth, and families across Turtle Island. I just feel humbled and honored to be here to share space with such incredible people, and truly believe that your communities and your people are blessed to have you and the work that you're doing. And so just a bit about the work ahead of us. And so following the Supreme Court of Canada's decision on February 9th, we know that the Supreme Court upheld all aspects of the Act respecting First Nations, Inuit, and Métis children, youth, and families. And so to create a better understanding of what that means, we have invited our expert panel today to share space with us regarding that decision, what that might mean, and to answer questions that you may have. We have received several questions in advance, and we will also open up the floor to other questions that anyone may have. I also just wanted to share that all participants who have registered for today will be added to the Our Children Our Way national distribution list. And that will ensure that you receive updates on future webinars, conferences, and any of the work of our society. And certainly if you don't want to be part of that distribution list, you're welcome to unsubscribe. Super easy to do. I want to ensure that everyone knows that the webinar today will be recorded. It will be uploaded to our website. And so if you don't want to have your face on the recording for today, you're welcome to also turn your camera off. But we certainly love to see everyone's beautiful faces. And then also just wanted to let everyone know that the Our Children Our Way Society is in the process of planning second conference for 2024. And so Loving Justice, a forum to breathe life into our own laws, will take place September 9th to the 11th at the Vancouver Convention Center. And so please stay tuned for updates around that through our website. We look forward to seeing everybody there. And with all of that said, just want to take an opportunity to introduce our experts today, beautiful human beings doing incredible work on behalf of Indigenous children, youth, and families. And so I feel very humbled to be in the virtual room today. But I want to take this opportunity to introduce who we're going to share space with this morning. And so want to start off by introducing Naiomi Metallic, who is Mi'kmaq. Naiomi, I apologize. I don't know how to introduce your nation. And so I feel like I probably shouldn't try because I will massacre that. So I do apologize for that. Naiomi's nation is located on the Gaspé coast of Quebec, known as the
Kaskabewagi district, and I'm from Listigouche. There you go. All good.
Thank you so much. Naiomi speaks English, French, and is becoming fluent in Mi'kmaq. After nearly 10 years of a very rewarding practice in Aboriginal law, she decided to make the move to academia to continue her work for First Nations in a very different way, through teaching, writing, and speaking about the issues facing Indigenous peoples in Canada and how the law can be a tool for reconciliation and improving the lives of Indigenous people. Naiomi now works on constitutional law, administrative law, Indigenous law, and all areas of Aboriginal law and policy. So welcome, Naiomi, and thank you so much for being here. I keep saying this morning. I should say today because I recognize it's not morning for other people. I also want to introduce Mary Teegee Gray. Mary is Gitxsan and Carrier from Takla First Nation and is a proud member of the Luggibu Wolf Clan. Mary is the Executive Director of Child and Family Services at Carrier Sekani Family Services, where she oversees the provincially delegated programs, youth services, family preservation, maternal child health, and the Highway of Tears initiative, as well as a violence prevention program. Mary holds an executive MBA in Indigenous Business and Leadership from Simon Fraser University and received the Dean's Convocation Medal for being in the top 5% of her class. Mary is also our chair at the Indigenous Child and Family Service Directors, Our Children, Our Way Society. And of course, we know that that is just a small snippet of who Mary is in the world. And we've recently just come from several days of meetings. And as I shared yesterday, Mary knows a lot about everything there is to know in the world. So welcome, Mary. It's good to have you here this morning and to hear more about all of your brilliance. And of course, also want to humbly introduce everyone, although I don't think she needs much introduction. I feel that you are incredibly famous across Turtle Island, but want to introduce Dr. Cindy Blackstock. Order of Canada is a social worker, author, professor, and child's right advocate, born in Burns Lake, BC. Dr. Blackstock is nationally and internationally respected advocate for the rights of Indigenous children. She co-founded the First Nations Child and Family Caring Society in 1998. Later, Cindy led the organization's case against the federal government from 2007 to 16. The Caring Society argued child welfare services provided to First Nations children and families on reserve were discriminatory and flawed. And Dr. Blackstock and the Caring Society continued to work towards improving child and family services for Indigenous children, youth across Canada. So welcome to you as well, Dr. Blackstock. It's always wonderful to share space with you. And I raise my hands to you for the incredible work that you continue to do on behalf of Indigenous children, youth, and families. So with that, I'm going to turn the floor over to our chair, Mary Teegee, for any opening remarks that you may have. And then Naiomi will go over to you for any opening remarks that you may have. And then Cindy, we'll turn it over to you.
Thank you so much, Jennifer. And I'm coming to you from the beautiful territory of Lake Litani here in Prince George, British Columbia. I just have to say I am so honored and humbled, and just to be in the same space, sharing the same spirit with Naiomi and Cindy. I don't know how I got so lucky and fortunate to be with these amazing forces on this wonderful Day of Women, celebrating women. It was just such an honor that the Creator has given me. So I must thank the Creator for this day. I'm just really looking forward to this day. I can't wait for some of the questions and just to really get into this. But I just wanted to remind everybody that this work that we're doing, the C-92, has come from decades and decades of advocacy, and this fight has been ongoing for generations. And yesterday we just sort of went through the timeline, just here in British Columbia specifically, of some of the advocacy work that we had to do to get to this place. Starting in the 60s and 70s, having the Indian caravan go across Canada, and to really argue that our children were, the 60s group going into care. So our leaders, all the ones that have passed, are really the ones that we look to remind us that this work is just ongoing. It's another step to where we want to be, and that's true self-governance, that's true sovereignty. And so I just really wanted to recognize all the ones that are not here to celebrate this win with us, but also to remind everybody that there's still a lot of work going on. But I'm excited about this day. So that'll be my opening comments.
Well, Dasi Begisin Gismel Liagwech, good afternoon, and I am joining you from xʷməthkվəy in Mi'kma'ki, so in Halifax, but I'm originally from another district, from Giskebeewagi. And I would like to say, Walaliek, we thank you. To Deb, thank you for opening up for us in such a nice way. And I'm just honored to be here to talk about the work that has been going on and where we are at, and to talk about the Supreme Court of Canada decision. And just really thankful for Creator putting me in Cindy's path somewhere along the way. I think around 2013 or 14 is where we crossed paths. We were both working on similar cases against the Harper government and started comparing notes, and it's been history since then. So glad to be here. Valio.
So good afternoon, everyone. I'm Cindy Blackstock. I'm Gitxsan, and I'm really honored to be joining you from unceded and unsurrendered Algonquin territory. Jennifer, really want to thank you and your team for making space for hosting these webinars. Thank you for the warm welcome. Thank you, Deb. Always a privilege to be in your company. You're such a guiding light for me personally, and I know for many, many others, and a real inspiration. Deb, for everybody, was one of the people that I was looked up to and continue to look up to learn more about First Nations Child and Family Services and how to do loving justice, as Elmer Corshane would later call it, for First Nations children. So I'm eternally grateful and so glad that our paths get to join every once in a while as well. And a real privilege to be on here with Mary and with Naiomi. And, when I think about jurisdiction, I sometimes worry that people start to think it's something that you sign. It's actually not something that you sign. It's something that you do. And you don't have to wait to sign something to actually exercise jurisdiction in sometimes the most important ways for children. What do I mean by that is that in community, we have some things where you say, well, somebody has to say something or someone has to do something. Well, exercising jurisdiction is when you are the person to say something and do something, even when it's hard for children. So I just want to remind us that jurisdiction isn't something up here, it's something in here. And each of us every day makes choices about how we can use our heart and use our love for children as an expression of jurisdiction. And if we all did that, then the feds and the provinces would all have to come into line, because we'd already be doing it in the most important ways, the ways that are familiar to the ancestors that were passed down to each one of us. So with those words, I think that's, I will be quiet, because I think that I know that Mary and Naiomi in particular have a lot of great information to share with all of you. So maybe we could bring up the slides.
Okay, I think this is mine, unless I'm stepping on somebody's toes.
Yeah.
Okay, so we sort of have a game plan here. So we thought we'd start by giving an overview of the Act, although I'm sure many of you are familiar with it, but I'll try to be short, and then if Cindy or Mary feel that we should add to it, we will do that. But many of us are familiar with the Act now, passed around 2019 by the federal government. Really the first of its kind, in that it is the first statute to recognize the inherent right to self-government in respect of children and families. That's stated in the Act. It's the first time the government's actually asserted anything like that, which is one of the things that Quebec had an issue with, but we can get to that. As well as saying that this was a part of implementing the UN Declaration on the Rights of Indigenous Peoples. And it also sets out national standards, and these are sort of minimum standards that apply until and continue to even after Indigenous communities start exercising their own laws, but it applies to provinces as well. It's a sort of an overlay of really fundamental rights that families and communities and children going through child welfare processes, rights that they have. It includes recognition of their right to substantive equality, to cultural continuity, and there are in particular placement provisions to ensure to try to curb overrepresentation of our children in the child welfare system. So it's setting forth principles that have to be applied by any decision maker in child welfare matters, that really puts a huge priority on children staying in their communities and with their families. And also it sets out the best interest of the child, but a specific definition for the best interest of the Indigenous child. In addition to the national standards, as I was mentioning, it creates a pathway for jurisdiction or self-government, ways that communities can start exercising jurisdiction. And in that regard, the national standards continue to apply. That's what the Act says, as well as requirements for the Canadian Human Rights Act and the Charter to apply to future exercises of jurisdiction. I think I'll stop there and let Cindy and Mary, if they want to jump in to speak about the Act.
I'll just actually, I got a question last week, and I actually remembered to bring this up, that the Act, the C-92, wasn't something that was led by, or was really imposed by the government. That was what I was, one of the questions was that, well, they imposed this flawed Act on us, but actually it was something that, as I said at the very beginning, that we were advocating for decades to have our own say, because at the heart of jurisdiction is our ability to make decisions. And I say that again and again, so it's so important. So the way that this came about, this Act came about, is, if you recall, 2012, 2013, 2014, there really was a push by leaders and advocates, child welfare advocates, to say we needed to be able to make better decisions because it wasn't happening in the provinces. We know the outcomes in the provinces under the ministry care is not good. So we had to do something. And then Minister Philpott, if you recall, called it a humanitarian crisis. And shortly after that, at the National Advisory Committee for Child and Family Service Long-Term Reform, we had drafted a resolution to go to the AFN to actually co-draft, I was hoping the wording, but it was co-develop federal enabling legislation. Once the resolution was passed, I moved that resolution as a proxy for Tackla Nation, and the person that seconded that resolution was at the time Chief Cadmus Delorme, who went on to develop the first their first family law and act, and that was the Tsleil Nation. So this was something that we had really advocated for. Then right after that, there was a legislative working group that worked with Canada to really try to bring forward what we wanted in this act. And we didn't get everything we wanted. There isn't a funding provision. It didn't go as far. Cindy was on the legislative working group. I was on the legislative working group, and other members of the National Advisory Committee and other leaders across Canada were part of that legislative working group. And we really tried to put in what we thought was really important. And one of the things I think that gets overlooked sometimes in this act is the phased in approach. We really wanted to ensure that there was opportunity for nations to be able to develop their jurisdictional tools, to develop their decision-making tools at their own pace. So you didn't need to do, say, for example, the full range of child protection if you weren't ready. It allowed for nations to go at their own pace, to build the capacity so no child could fall through the cracks, and then take on another body of work when they were ready. So this act is actually something that, you know, we've been working on. We know that I don't think any of us were surprised that there was going to be a court challenge. In fact, we called it. We said it was probably going to be Quebec. But I think now the way that the Quebec reference case, the way that it was worded, I think was very, very strong in the wording. I think they were very meticulous in looking at what they needed to write, and so that they could get a unanimous decision. But definitely there is still a lot of work to be done, but I just wanted to make sure that everybody understood it was something that we really supported and really pushed for. Cindy?
Yeah, I just I want to echo what Mary's saying. And in fact, if you look back at the National Policy Review in 2000, that was the original report that really calculated the shortfalls in First Nations Child and Family Services at 22% less than mainstream. That's the top recommendation, is jurisdiction. Having said that, and you'll hear me say this later, there are some big gaps in C-92, and one of them has to deal with obligations of the Crown to fund. So we'll get to that later, but yeah.
Okay, so some of the key facts right now, of course, we know First Nations children are overrepresented at 17.2 times the rate of other children. I think this is a really important number. So this comes out of the First Nations Critical Incident Study that was conducted in 2019. 72% of First Nations children in care are off reserve and predominantly served by the province. Later, we'll talk about how what some of the other provinces are doing, but there definitely needs to be, we need to turn our focus to ensure that our citizens that are living off reserve are also taken care of in a good way when it comes to funding. So, of course, the main reasons why First Nations go into care are addictions, domestic violence, mental health, poverty, poor housing, all the impacts of residential school and colonization. We definitely see the hurts of our people every day with the opioid crisis. So these are, and I say all this all the time, it's unprecedented times when we look at the opioid crisis that we're dealing with. You know, our communities are being ravaged, where our children are losing their parents. Our children themselves at a very young age are getting addicted. So we really, really have to come together, utilizing all the tools that we have, both practice tools, but also these legislative tools that we need to create and need to breathe life into to ensure that we're dealing with all of those issues that are plaguing our nations. Next slide. What are the problems we need to solve in child and family services? I think one of the things, the drivers of child maltreatment, and I often we talk about the impacts of residential school, the impacts of colonization, and we really need to be real about what is happening in our communities. I think, you know, the clearer you are about the problems and the challenges and the issues, the better solutions you could come up with. And so the act is a simple tool, but it's not a simple tool, but it is a tool for us to be able to make decisions in our nations. But also we can't lose sight of the Canadian Human Rights Tribunal and the impact that has on our nations, because we've always said we've had the inherent right to take care of our children. We've always had jurisdiction. We've just never had the resources to breathe life into our own laws. So when we start thinking about developing our laws, we have to think about the actual practice and capacity that that we need to implement, because that's why the only reason that we have this, the Act, is to deal with the child and family issues that's plaguing our nations, and so that we could get into a place where no children have to go into care. So some of the problems that we have to solve is to stop Canada's discrimination and ensure substantive equality, to stop the provincial discrimination and ensure substantive equality. And also we have to be really accountable to our children and youth, not only the ones that are here today, but those not yet born. And so when we think about all the services that we need, you know, we've had a long history of being underfunded by the federal government and the provincial government. So it's going to take some of the nations longer to build that capacity to address the issues that we see within our children and families. And we always have to remember to always trust who we are as Indigenous people, because at our core and in our heart, we're the ones that know what's best for our children. And that's what this Act allows us to do. We have to be very clear about the realities in community, because we can't lose sight of the realities in our community. We have issues stemming from the residential school. We have to deal with issues of sexual abuse. We have to deal, you know, with the hidden domestic violence. We have to deal with these issues. But first and foremost, I think we really need to be true to who we are, but we need to really look at the realities in our communities. And some of the structural problems affecting the child welfare system. I think Cindy will also speak to this slide, but the numbers are just way too high. Like, we need to know that the 72% of all First Nations children in care are off reserve. We know that's high, but we also know that right now there's discriminatory funding with the provinces because they have not implemented the Canadian Human Rights Tribunal orders. So we must focus, child welfare reform has to focus on reducing our children and going into care, but we also have to take into consideration all our young citizens, all our children and families. We also need to ensure that the child welfare legislation has very limited control over structural risks. And so we always ask the question, you know, what is this Act trying to, what are we trying to solve? What problems are we trying to solve? And we can't lose sight that this Act, and you'll see this later, that there are issues that this Act won't be able to solve, but it's us and the work that we do on the ground that helps solve those problems. It's but we need the funding to do that good work, and we need accountability and we need evaluation. We need to do all of these things to ensure that we're dealing with those structural drivers, such as mental health, addictions, domestic violence, poverty, poor housing. And I think when we did the touchstones of work years and years ago, you know, there were leaders from all international leaders that were really looking at how can we better the lives of Indigenous children and families. And over 20 years ago, we held a meeting at Niagara on the Lake, and the Touchstones of Hope came to be. And that was all the recommendations and utilizing, you know, the best minds at the time to say, how can we deal with these issues? And one of the things that always stayed with me was a principle around those structural interventions, that no child should go into care for reasons beyond that child or family's control. They have no control about, you know, the issues of poverty or all of these things that they can't deal with, like the lack of housing, all of the stuff that faces in communities. That shouldn't be the reason why children go into care. Of course, there are those extreme cases where children have to go in care, you know, the sexual abuse, all the different abuses. But really, that I really love that principle, and it comes from a place of love. Like, all of us know that the highest principle that we have, the highest law that we have, is the law of love. In our potlatch, you know, both Cindy and I are Giksan, we celebrate that. That is the highest law of love. So when you look at that and you look at the principles that we have as Indigenous people, we are able, I know, just using our laws and our principles, we're able to overcome those structural drivers, but we need the resources and the funding to do so.
Yeah, and one of the things that I think is really important is that all of us can think about inquiries, inquests, provincial advocate reports, royal commissions, everything, where people have been recommending change for child welfare, only to see the system not really improve. And one of the reasons is that people really focus at the top end of it. They don't deal with the real issues of poverty and addictions and mental health. And those, they're structural drivers, but I call them fires. And they're the same fires that fuel the overrepresentation of young people in juvenile justice, the poor educational outcomes, etc. So if we continue to tinker around with child welfare, but we don't deal with the major fire that's burning underneath it, it frankly won't matter how good your law is. You're not going to see the types of gains you want for your children and families. Another kind of star to this is when I look at the provincial legislation, there's some good stuff in there. So it's not necessary to rewrite everything in the Provincial Act, I think, if you take a close look at it. A lot is possible to deliver culturally based services under provincial legislation. But the one that I have always been preoccupied is the definition of neglect. And the reason is because it codifies these structural problems that are largely outside of families' ability to control as a parental deficit. So the legislation will read, parent is unwilling or unable. And the solution to that is some child protection intervention. Well, I've always felt like we should hold parents' feet to the fire for things they can change, but we should actually hold government's feet to the fire for things that are putting kids at risk that are beyond their ability to control. So we'll get later to what you can do with jurisdiction. That definition of neglect is one of the ones I'd highlight. Thanks, Mary. Mary,
You're
I
on
think you're
mute.
muted.
Yeah, my dog was barking for a bit, my Finnegan. So I think we just talked about sort of some of the, what jurisdiction can't solve, like sort of the things that are on the ground. There's a lot of, I always like the question that Cindy asked very early on, quite a few years ago. And she said, well, what problems are we trying to solve with jurisdiction? And the answer came back was, domestic violence, like all of these things. But when we started looking at it, it wasn't actually that. And so I think, Naiomi, what problems can jurisdiction solve?
I mean, because of the way that the federal and provincial governments have handled a lot of our services and taken so much control away, I mean, I do certainly think that, the way that the provision of not just child welfare services, housing, like it's all been structured over the years where the federal government borrows provincial rules that were not designed for us, that do not have us in mind, and then impose them in our communities. And so that really doesn't work. Oh, I get a coffee. That's delivery. Thank you. And so I think that it is important because so much control has been taken from us, and it's recognized in the CHRT decision, as well as many other places, that when Indigenous people are able to design services and control their destinies, they have better results. So it's about results, and I think that's the thing to remember in all this. And I love how both you and Cindy are emphasizing this. We're not seeking jurisdiction. Jurisdiction is not an end in itself. It's not just self-government for the purposes of self-government. It's self-government for the purposes of making our kids' lives better and our families' lives better. And so I think that there is a really important link, because jurisdiction can make our life better because, we've had so much control exerted over us. But we cannot lose sight of the fact that we have obligations, accountability, and responsibilities. And jurisdiction is that. So Cindy started off talking to us about leadership and as jurisdiction. And I think that that's a really key point that we can't lose sight of in this exciting time where we're finally having these conversations about jurisdiction. We just can't lose sight of that.
I think it's also what problems jurisdiction can solve. I know that sometimes, and the way we talk about the system and how that hasn't worked for us. And, we're constantly butting head against the system and feeling, and I know this, our social workers, our frontline workers felt really disempowered because of the policies that don't work for our people. So this law would allow us to really look at what is good practice based in our cultural ways of knowing, based in our culture, and incorporating culture and those traditional activities as good practice. Those practices then makes those good standards of how we want to take care of our children. For example, 1 social worker to 4 children, for example. Then those standards develop, we develop the policies within our jurisdiction, and those policies then make the good laws. And so those are the problems that jurisdiction can solve, where we could really embed that good practice in our laws, but also those accountability measures that can be embedded within our laws. We also have to think about how is it that we are identifying risk. We know one of the biggest reasons for our children are going into care is because of the definition of risk. It's very, very demoralizing. We're held to a standard that is not of our making. It's more of a Western standard. So we have this opportunity, and this you can do right now, is to look at making decisions based on the strengths of the family, the nation, and the clan, not looking at their deficits. And we know that. So for example, you look at a little child on the ground who knows, okay, if mom and dad are drinking, I don't feel safe here. They know I'm going to go to grandma's house. I'm going to go to auntie's house down the road. So we already know we have these strengths in our families. And so those are the things that you could bring to life and really embed in your jurisdiction. So at the end of the day, it's incorporating our traditional laws and our principles, and really allowing us the way to make decisions in a good way, utilizing cultural as our foundation. What problems can community solve? I think we've had some conversations about that. I like Cindy's always talking about these courageous conversations, the courageous actions that we need to do, using evidence to inform programs. Again, we also have to look at all the good research that has been done over the years. We have a lot of now more Indigenous researchers that we know what works that works for Indigenous families and children. We really need to utilize all the existing information that we have. Targeting those funds to drivers of neglect. Again, when you're looking at your laws and you're looking at the funding provisions, to start thinking about what is it that causes that family to be at risk of going into care. Those issues of poverty, the issues of poor housing, to actually have a housing strategy, developing, poverty strategies, doing all these things in community that we can use, but you don't necessarily need a law to do that right now. Also addressing the sexual, physical, emotional maltreatment. We know that I know across Canada, I know this is a crisis just to get good mental health workers in community, the shortage of psychologists, psychiatrists, child psychologists. I know in the northern British Columbia, we don't have 1 child psychiatrist right now providing support and services, but there's other things that we can do. We know those traditional practices. We know those, the way that we did ceremony incorporating, those things we can do right now to really come together, and then utilizing those Western modalities of treatment or mental health treatment. We have to incorporate them both, but there's things that we can do right now. Again, directing the funds to those most able to help children immediately, and developing long-term plans and measuring progress. And again, that would be based on what your community sees as a well child, or what does a well community look like. Those are things that we can do right now and start, collecting that data. But I think it's really important to remember that for me, jurisdiction is really, everything we do as leaders is about our children. So jurisdiction is really centered around our children. And so if our leaders are not making decisions about that is totally centered around our children right now, but those that are yet to come, that they've failed our children and they've failed our families. So I think these things are things right now, is to always put whatever we're doing right now and put the child as our most important resource at the center. And I think that's how we can solve those community problems. And I think Cindy can speak to this, but one of the things that, we talk about equality and then substantive equality. And, if you give everybody that in Canada to say, okay, well, we're going to deal with poverty, and we definitely see this child poverty, and we're going to give every Canadian X amount of dollars, $100, everybody to deal with child poverty. We know that in the First Nations community that we have gone through impacts of colonization, impacts of residential schools, so that we actually need more to be at the same level as the rest of Canadians. We also have to think about and I think sometimes this is that we forget about this. There was research done before where services, so mental health services, so they talk to counselors, practitioners in the mental health field, and in Western based or non-Indigenous communities, non-Indigenous people, they would have like maybe 2 people that were that they would be providing services to that had post-traumatic stress disorder. So if they had like 20 clients, 2 of those 20 clients would be going through PTSD. Then you compare that to Indigenous people, and I would argue that all of us are going through some type of post-traumatic stress disorder. So everybody's dealing with trauma in the Indigenous community. So instead of having 20 people as a mental health person can take care of, that person that's working with First Nations community maybe only can handle maybe 10 or 5. And again, like just looking at substantive equality from a service lens. Cindy, did you want to speak to that?
Now, just briefly, there's lots of great research that shows that this is one of the most important things in terms of remedying cross-cutting disadvantage in populations, is reducing the inequalities and making sure that people's they have the same opportunity to succeed as other people in the society. So I'm not going to go into it a lot here, but you can look at the World Health Organization's reports authored by Sir Michael Marmot, or even just watch them on YouTube, and you're going to see so much of this convincing data. We also, under Michael's leadership, did a Pan American Health Organization study on health equity and inequity. And health, I mean, in the broadest sense, focused on Indigenous peoples and focused on persons of Afro descent. So you can Google that, PAHO study, health equity and inequity, living dignified lives, and you can find all the research there too.
I think just listen to you, Cindy. One of the things that, again, the principles that you can embed in your laws is just that, we always say this, we're only as strong as our weakest member. And we think about in our communities, and I just know the realities in our community. Usually it's the ones that have, that are autistic or that have special needs, that there are no ways, the resources to take care, we can't take care of them just because of the resources. But traditionally, like, we all came together and took care of our weakest ones, and that's where we need to get back to. And I think when we think about the substantive equity, that's really the fundamental laws within our potlatch system. The clans gather money and they give it back out to meet the needs of the community, so that everybody had enough to sustain life and live with dignity. And I always like that Cindy says that. So the research that we show, of course, shows the equity between economic well-being, reductions in social problems, improvements in health, education, and wellness, and the importance of actually investing early in those early years, investing, with before the baby's even born. Like, all of these things, I would say that even that our little baby, when they're in the tummy within the womb, that they deserve substantive equity. And how do we do that? So we really have to think about this in when you're looking at your laws and you're looking at your funding, when you're developing your laws, to think about what does that look like traditionally for you and for your laws in your own traditional governing structures. Hey, Cindy.
All right. Just a quick reminder, we're going to go through this quickly. I know there's a lot of stuff and we want to make sure that we cover a lot on C-92, but there's a lot of moving parts right now on the tribunal. And the tribunal really is about substantive equality when you really think about it. I mean, it was, well, I really welcome everyone to read Naiomi's paper, because I think that this was really a breaking of the dike when the tribunal made its 2016 order and really centered the right of substantive equality and also Indigenous people's rights within the framework of children and families. So if you haven't read their 2016 CHRT2 decision, you should. And the first sentence of that decision is, this decision is about children. And I always encourage people in jurisdiction, or no matter what you're doing, think about how your decision-making affects the level of the child. Because sometimes it's easy to say you're talking about children, we're doing this for children, But then we forget about, well, how does this actually look like for children? And that's the real test, I think, in all of this. So the tribunal case is really about ending discrimination by Canada against First Nations children, youth, and families now and forever. This is our chance at the forever. That's the biggest challenge of the case, as far as I'm concerned, in Child and Family and Jordan's Principle. It's now 17 years old. It's still ongoing, this particular case. So we'll go to the next slide. So we've achieved a lot, and I always want to recognize everyone who even came before the decades and centuries of struggle that preceded the decision. But we've now had over 4 million services in Jordan's Principle and over $20 billion in new supports, but that's only over 5 years. So, by the way, we're in year two of the 5. So what happens 3 years from now? That's the $1 million question, or maybe $1 billion question. And also the compensation, which you all know quite a bit about. So I'm not going to go into detail with it right here. So I just want to kind of center this back, because sometimes we hear a lot of focus on, well, we need to reach a final settlement agreement. That's the only way to resolve it. That's one way to resolve the case in terms of achieving Canada's stopping discrimination and then preventing it. It's only one way. You can negotiate with Canada and you can hopefully get them to agree to things. But it does take them agreeing to it. Is the red herring. And then even if they agree to it, they have to implement it. And we all have seen treaties and other things where they agree, but then implementation falls short. So if there's a final settlement agreement, it needs to be approved by the First Nations and Assembly and the tribunal in order for the tribunal to feel like it's done its job and then to relinquish jurisdiction, which means that the tribunal can't make any further orders on the case. Then on the right-hand side, you could actually resolve this by just, bringing motions to the tribunal, saying this is what we think the best solutions are for Child and Family and Jordan's Principle to the tribunal. That doesn't require any approval from Canada. You argue it out, but then the tribunal makes the ultimate decision. The good thing about the tribunal process is it's public, and I should have said on negotiations is typically they're done in private. So I personally like the public facing part of the tribunal process. And then there's a possibility of doing both, resolving by both. So I just want to remind people it's negotiations plus could be the strategy. Let's take a look. So there's been a lot of evolution in service providers in Child and Family since 2016. This tribunal decision, I think, can be thanked for that in terms of opening up pathways for different types of models of Child and Family. That's a good thing, but it's also introduced some challenges that can be overcome for sure. But they primarily relate to kind of ensuring that those who are just starting out have sufficient capacity, including a workforce, in order to be able to discharge their responsibilities under the national standards of the Act and according to provincial legislation as well. Next slide. So this is a draft funding model that was done in collaboration with First Nations and First Nations agencies. And it was put forward by the Institute of Fiscal Studies and Democracy. I'm not going to go through a lot of it right now, but this is the type of evidence-based approach that we need to see at the end of the day, because this is a way that you can make sure that you have the needs of children covered, but also that you can hold governments accountable for non-discrimination over the longer run. So this is the general approach. It could change. It has to be reviewed by First Nations experts. Of course, leadership has to take a look at this, and then we have the tribunal. But this is a current thinking about what it could look like. And I want to get to the next slide because the reason I'm including this one is because I want to show you eventually how you can get a hold of Helena and find out if you're a First Nation agency or a First Nation without an agency. You can actually see what your budgets are under the proposed formula. So you can see what it would look like for you. And I think that's important information. In addition to that funding structure, you would have regional and national pools. This is coming out of a discussion at the National Advisory Committee. I want to acknowledge my colleagues and also say that this hasn't been absolutely finalized, but there was a sense that because the agency funding model is a block, you need to have some safety nets given the long-term inequalities. So the idea is to have a safety net for those First Nations that were under this egregious 20-1, which is the lowest funding formula from the federal government, up until 2016, and that would be BC, Yukon, Newfoundland, and Labrador, and New Brunswick, just so that they can ramp up to the same level as everybody else. Extenuating circumstances or high-cost kids generally is just a way of doing business, but high-cost children. And then emergencies, which could be civil unrest, natural disasters, those kinds of things. So this is still in conversation, but this is the current thinking. Next slide. And then there will be secretariats, so national and then regional. These are technical, non-political things that really respond to the needs in your different areas. But there will be funding for these things. So it could be one organization, it could be a series of organizations. Maybe you've already got somebody collecting data and you say, why invent the wheel? We'll just give some of the money to them. But this is part of this holistic kind of a funding approach. Next slide. So this deserves a full ventilation on its own, and but I really want everyone to reach out to Helena Gaspard to find out what their First Nations Child Family Service Agency budget would be under the new model. And if you're a First Nation that's not serviced by an agency, you can also find out what your budget would be under the proposed funding model. So yeah, and I know Helena is very busy. We are doing a lot of incredible work. I want to recognize her and the whole team at IFSD. But it's also very helpful, I find, to have her presented so that you can see all the different nuances, ask your important questions. But the one thing that I've learned over the years is that when it comes to funding, it's the purpose, the principles. I would throw in the definitions, the structure, and the enforcement. Those are key to making sure you have adequate funds over the longer run. If you just get the funding level and you focus on that, then it'll probably do you well for a while. But then the question comes, well, what if it's not enough? And that's where all these other things are really, really important in order to ensure that your funding is at an adequate level, even if the government is unwilling to increase it. You could take them to court and enforce it this way if you have these other pieces right. Next slide. So this is over to Mary, I think.
Hi, sorry about that. Just I had to put my puppy outside. He was barking. I think the as I was saying earlier, there's a real big inequity. The CHRT, as you know, it was for children on reserve that were removed on reserve, and the province provides funding and resources for those ones off reserve. We know that 70% of all First Nations children are living off reserve. And so the Supreme Court decision, C-92, references Jordan's principle to ensure that First Nations children do not fall through the cracks. Jordan's principle is for, there's, for the status children, non-status, and for the ones that the nation considers their citizens. And that's a really important point. I know we often get asked that, but yes, like if somebody lives in your community that may not be from the nation, but the nation and the Chief and Council recognize that person, they're eligible for Jordan's principle. We do not have right now in the province of British Columbia or any of the provinces where none of the provinces have adopted the Canadian Human Rights Tribunal orders. And so what we have is this really, really horrific discrimination, and it's very, very real. And I always use an example where we're able on reserve to provide housing and like to provide a safe home for those children. We can provide, additional supports for grandmothers, auntie, to take care of those children, to provide, their basic necessities. But you look at off reserve, and we're not able to do the same at the same level. So these children off reserve are not receiving the same supports. And I think that's where we need to turn our minds to. I do know, like, for example, in the province of British Columbia, we have asked the Premier to sit down and negotiate long-term reform with us. Or we would have to perhaps entertain a human rights case against the province of BC, just so we could get justice and that substantive equality for all our children, regardless of residency.
This is back to me. I just want to say that we've Jordan's principle, we're seeing some pretty serious non-compliance across the country. I'm not going to go through all the issues here. You can see them on the slide: unopened cases, not responding to efforts to make requests, lack of timely and compassionate response. And the problem with all of this is it has real impacts on kids and families. So here at the Caring Society, with permission of families, we're going to share some of the stories in our affidavits that in non-identifying ways. So to give you an example, we've had parents fleeing domestic violence who've had the courage to do that with their children. And they've been asking for urgent supports from Jordan's principle to get themselves set up in a safe space, but they can't reach anybody in order to do that. We've had children in palliative care whose parents, instead of just spending that sacred time with their child and in ceremony, are actually on the phone trying to reach somebody at Jordan's principle. So Spirit Bear here and has been funding some of these families just so that they can have that sacred time. First Nations are doing it across the country. There's serious non-compliance. So we have been flagging the non-compliance, calling on Canada to fix it, even suggesting solutions, and Canada hasn't done it. So as of December 12th, 2023, the Caring Society filed a non-compliance order against Canada, and that's currently working its way through the tribunal. So we'll just let you know where that's at. So there's the date we filed the motion. Our affidavits were filed on January 12th, 2024. You can, again, reminder, anything before the tribunal is public. So go check out our affidavits. You can read them at fnwitness.ca. Next Friday, the AFN and Canada will file their materials. So as of, say, Monday, you should be able to go to FN Witness and read what they have to say about it. The hearing is June 3rd to 4th, 2024 here in Ottawa. It is open to the public and it will be webcast. So no matter where you are, you'll be able to watch it. Canada is clearly opposed to it. And the Canadian Human Rights Commission is supporting it. Anishinaabe, Aski Nation, Chiefs of Ontario, and AFN have not yet taken a position, but we'll get to see that fairly soon. Next slide. So the Caring Society is outside of the agreement in principle as a result of filing this non-compliance motion. There was a clause in the agreement in principle that said you couldn't file non-compliance motions. So for that reason, we left. We remain committed to ensuring that discrimination stops and will not happen again, and contributing in whatever ways we can to either a final settlement agreement, to a litigation pathway, or both. We really want to respect the privacy of the other parties. We understand that they're taking approaches that they feel are in the best interest of children and families. But given that we're on the outside, we feel we need to publicly be accountable to leadership. So we'll be posting our positions so that everyone can hold us accountable. And even better, if you see one of our positions and you think, well, we have a better idea, then you can let us know about that better idea, because we really want to benefit kids and families. Next slide.
So Cindy, can I just make a point of the last slide is to remind everybody that the outside the AIP process, like when you're there at the table, you're agreeing to negotiate an agreement in principle, and then you go to a final settlement agreement. Now, because we have a non-compliance order and you're expecting Canada to act in good faith, and if they're not even able to uphold the Canadian Human Rights Tribunal, we cannot we cannot, in good faith ourselves, say that we trust Canada to actually uphold whatever comes out of that final settlement agreement, and that they're actually negotiating in good faith at the agreement in principle, because there's this non-compliance of Jordan's principle. And so I think that's a really important point.
Okay, I think this is where I step back in for a little bit to talk a little bit about some of the main holdings out of the Supreme Court's decision. It was a month ago tomorrow that we got the decision. And so it is a unanimous decision from the whole court, written as the court, which is, I think, important, and part of the reason why it took as long as it took, because they were trying to work together to come to a decision where they would all sign on to it. And that's important. It actually, I think, sends the message that, you know, they saw this as serious. They wanted to speak as one voice. Often it's very hard for the court to speak as one voice, so they decided to come together and speak as one voice. So that's significant in itself. The court upheld the constitutionality of the entire act. The government of Quebec was challenging both Canada's ability to pass the national standards as well as create a pathway to self-government. The Quebec Court of Appeal had struck down part of the act that makes laws that Indigenous laws that are made under a coordination agreement or with efforts to make a coordination agreement for a year. The Quebec Court of Appeal said those parts of the act were unconstitutional, but the Supreme Court disagreed. They said the whole act is constitutional. And the decision really does, and center the voice of children and families in the decision. We felt, you know, as the Caring Society, we had tried really hard to make sure, but the court has various parts where they speak about that. They also talk about reconciliation a lot. I think it's referenced something like 64 times in the decision. It clearly was weighing a lot on their minds when talking about the act. They called the act a sort of an attempt at legislative reconciliation. And they also said that because the government took these steps, it also is bound by them. And they recognize that Canada bound itself as well as provincial governments around this act. And so there's a really interesting aspects of the case where the court tells us that the government's got to not only just recognize self-government, it's got to act as if self-government is that it exists, and it can't act any way contrary to that. And the court spoke about the honor of the crown and how that is going to be used to bind the crown. And so we think that that's a really helpful aspect of the case, where essentially the way I see it is that the court says, look, Canada, if you're going to talk the talk, if you want to say self-government exists and respect self-government, you got to walk the walk. And that means you got to respect it. You can't try to take positions that are contrary to it at negotiation tables, and you've got to act in ways that uphold the honor of the crown. So I think that that's really important. And as part of that, the court really emphasized the UN Declaration on the Rights of Indigenous Peoples. It's referenced in the in C-92 itself, and the court recognizes that, and this as an effort to implement UNDRIP. And so the court also, at many points draws on several different articles of UNDRIP and says UNDRIP applies in Canadian law. It references the Federal Act on UNDRIP and says that it now applies in Canadian law. It binds the federal government, and also the court said in implementing C-92, UNDRIP's going to be relevant, and we can look to the standards of UNDRIP as well in holding Canada accountable. So that's really helpful, as well as the mention of Jordan's principle in the decision, and recognizing it as an important legal principle that we can draw on as well to hold governments accountable. So that's really helpful as well. A few other points that I'll say here is that some people have asked, because we see now all these examples around us of some provinces relying on the notwithstanding clause in the charter to say no, these fundamental rights don't apply. I just want to be extremely clear that that cannot be done in this case, because we're not dealing with charter rights. We're dealing with division of powers and Section 35. There's no ability for governments to try to get out of it by using the notwithstanding clause. That is a no, a clear no that they can do that. So I'm glad that that's off the table. Yes, and the Act, the way that the Supreme Court decided to approach this is they decided it under Section 9124, which is the federal government's ability to pass laws in relation to Indigenous peoples and their and lands. And they could have resolved it by going to the inherent right to self-government, as the Quebec Court of Appeal did, but they decided not to because they said they didn't have to, although they didn't disagree with the Quebec Court of Appeal or overturn them on the finding that, the inherent right to self-government exists and might underlie the Act. They just said for the reasons of not opening up more questions than we can answer, we want to decide it on the basis of this. And I know that some folks have been critical of that. For my own self, I felt that it would be good to give them more time for us to give them good answers to a lot of questions that do start to come up when you start unpacking self-government and what that means. And I worry because Canada was trying to float what some said was a fairly narrow definition of the right to self-government. So if we open that up, the court would have had to decide it then. And so they have suggested, as I say, they left us breadcrumbs in the decision that they're going to decide, in favor of self-government when the question comes up before them, but they didn't have to do it here. But they also said too that but Canada has recognized the inherent right to self-government, and it is bound to that, and the other actors are bound to it as well. So in a sense, it is recognized in the Act, and Canada cannot act contrary to that, so long as the Act is in place. So that's, I think, a helpful way to see that. Okay, I think that maybe next slide. And there are also more cases that we are waiting on coming from the Supreme Court, and another one to be heard. So one that was heard last February, so we should be getting a decision any moment now, deals with the application of the Canadian Charter of Rights and Freedoms, protections of equality rights and other fundamental rights, whether it applies to the exercise of self-government. Here it was a self-government agreement of a Yukon First Nation, and so the court will give us guidance on to what extent the charter applies, how UNDRIP comes into that, because there's a broader question. UNDRIP talks about the right to self-determination, but says that fundamental international human rights also apply. So maybe they'll give us some guidance about how these things come together. So waiting and seeing on that one, but we should get a decision soon. And then in April, the Supreme Court is deciding a case that has to do with chronic underfunding of policing services, a self-administered policing agreement of a First Nation in Quebec, who not only brought a case similar to Caring Society at the Human Rights Tribunal to find that this was, chronically underfunded, which they won. They also brought a case in the courts saying that this was contrary to their fiduciary duty of both of Canada and Quebec, as well as the honor of the Crown. The Quebec Court of Appeal found that they were correct in terms of the honor of the Crown, that Canada was obliged to provide services based on the honor of the Crown that met the needs of this particular community, and they couldn't just try to, use technical arguments about the funding agreement that they had to weasel out of it, essentially, both Quebec and Canada. So that's now being appealed up to the Supreme Court, and this decision will sort of put before the court the obligations of government when they sign funding agreements that have to do with rights to self-government and other important rights. And so we think that this is really important, and I think it's fair to say, Cindy, we are intervening as a caring society, and we'll be making arguments about that. You know, it's really important that the court uphold the Quebec Court of Appeal decision and emphasize that the honor of the Crown is related to funding and how important funding is. Because really, as we've said throughout this presentation, you know, without adequate funding, the right to self-government or jurisdiction is pretty hollow. So we need that, and that needs to be a part of it. And the signals that the court sent on this in the C-92 decision, I think, are good, and I think are leading us in the right direction. So we will see where that goes, but that is a really important case coming up in April.
So I'll take a stab at this. So what are some of the implications of this? And then Mary and Naiomi will be able to pick out a couple of things that I would think about. Is first is I echo Mary's message and also that of Naiomi and other experts. Take it slow. Don't feel like you have to do this overnight. Make sure that, you know, like ideally you're building capacity in your services so that when the day comes when your law takes effect, it's not even really noticeable for kids and families, because you've already curated all your services to that place where it's kind of like, okay, well, now we have jurisdiction, instead of trying to get all of the service pieces in order after that. So there's lots of reason for going slow. We're going to show you a slide on the Wakoto Lodge and Governance Center that's got all kinds of great resources. So don't feel like you have to do this overnight, and don't feel like you have to take everything over at one go. You could, for example, draw down your own standards or do other types of things. You don't have to do the full bit. Some nations have said, well, you know, before we write a child welfare law, we need a constitution. So they've actually been spending some time thinking about a constitution, and that way they could weave in their child welfare law. Maybe they're going to do health, maybe they're going to do education, but they've got that pillar to kind of nest things in. So that's an idea for consideration. There needs to be some mechanism to coordinate laws, and that's why I think one of the reasons, and Naiomi will correct me if I'm wrong, the Supreme Court included Jordan's principle in that C-92 decision, because they saw the potential for kids to fall between the cracks, because they have fallen between the cracks. So how do we coordinate laws across the country to make sure that all children are taken care of? Think about that definition of neglect, how you would craft that so it does hold caregivers accountable for things they can change, but doesn't hold them accountable for things that are beyond their reach. Think about a statutory funding provision, even in your own law. Get a hold of skilled lawyers like Naiomi and figure that one out. Consider the implications. There's a good decision on Jordan's principle, and that's the site of it, 2020 CHRT 36, that said that Canada has to fund First Nations children recognized by their nations off reserve. So that's been on the books for a while, and Canada tried to judicially review that to federal court, but the federal court did not grant that judicial review. So it's good law. It's out there. Take a look at that decision, see if that might be something that you'd want to use to build capacity, because there's two elements. One is this idea of recognition of First Nations children for funding by the federal government who are off reserve. And then second of all, there's monies available through that order for you to develop your own First Nations recognition process for children eligible for Jordan's principle who don't have status. Measures, I would think about really thinking through this extenuating circumstances thing to include even things like class actions. And one of the things I've been wondering a lot about is, what is the relationship between class actions and free, prior, and informed consent? Because what we have is you have a couple of representative plaintiffs who bring a class action, and there's payments to individuals, but then it's the community and the nation that has to try to rally around and provide supports for that person. They kind of come out of everywhere, and now they're coming out of everywhere, like literally. So there's different types of extenuating circumstances that are happening as time evolves. So we definitely need those things like climate emergencies, all those usual things that go into the bucket. But I think we need to step back and think more broadly about what extenuating circumstances and extraordinary circumstances are in this new environment. So those are just some of my thoughts, and I don't know, Naiomi and Mary, if you have others or if you want to contribute to the conversation on some of these.
I think some of the considerations, I always say this, to be very cautious, because there's a fine line between jurisdiction and offloading. You know, you look at, for example, the example here in British Columbia, where we have the first provincial act that is really harmonizing provincial acts and statutes to harmonize with the C-92. However, that is hollow. There's no funding for that. So, you know, we can make the decisions, but if we don't have the resources to uphold those decisions, you know, as you know, I think Cindy said, you know, that jurisdiction is hollow. So that is one of the considerations. We also have to consider the liabilities, you know, within your laws, and you know, we really haven't been able to nail down Canada to say, okay, you know, that there is going to be an indemnification clause. Like, the liability piece has to be really addressed and has to be considered when you're you know, when you're developing your own laws. The other piece too is, I think that the importance of really getting the within your own laws around the funding provisions, because right now the Institute of Fiscal Studies and Democracy, there's been a lot of research done, and how really really concentrating on the structure of the funding rather than, say, the amount. And that's really, I think, integral to anything that you're going to be putting within your laws. I know that the government will say, oh, you're going to get X amount of dollars or whatever, but we have to ensure that we're not putting our leadership in a place where that they are actually the ones that are going to be, you know, perhaps being charged later for discrimination because of funding doesn't meet the needs of the community now and on into the future. So these are some of the considerations that we really have to look at.
Yeah, so yesterday I had the great honor, along with Spirit Bear and Mary the Bear here, of doing a Spirit Bear podcast with Naiomi and her colleague Hadley Friedland on C-92. So that's going to be coming soon. I want to thank both of them for doing it, because I learned a lot going through this. And I think that's the thing, like, you know, you look at C-92, you think about things like constitutional law and all the rest of it, and it can feel like it's kind of going over your head. And I know that sometimes I feel that way too, but slowly things are landing on me. And I really, by having multiple learning opportunities like the one here today, but also through the podcast, and we put a link to an information sheet. So I just really encourage everyone to do that. We'll go to the next slide, please. And here is a fabulous resource I go to often to help, you know, not only help myself understand, but help myself to be able to more accurately communicate it to other people. There's wonderful infographics on here, resource sheets, all kinds of great stuff. And it's the Waututh Law and Governance Lodge out of the University of Alberta. And folks like Hadley Friedland and Corin Lightning Earl and Naiomi, and I think Sarah Morales does some great work out of there. Anyway, go and check out these free resources, because I just find them to be a real gold mine. Naiomi, do you want to say anything more about the lodge?
Only that they do some really great work in working with communities and working with their stories and their language in order to draw out from these wonderful resources, you know, our ways of doing things, right? So that, you know, you can talk to elders, you can talk to knowledge holders, but this is another resource, and they have some great workshops that they do that you can be a part of, and they can come do in the community. And there's other organizations that are doing this type of work, and it's really amazing. Like, we're looking here at Mi'kmaq stories, words in the Mi'kmaq language that really convey about our relationship and our obligations to our children and our families. So that's some great work that can help make sure that your laws really reflect your nation.
So the key takeaways are just summarized in this slide, but I just want to really emphasize to people about the importance of these tools that have been handed down to us by the struggles of so many. And it's been a real honor to join with all of you today. And thank you to Mary and Naiomi for this great webinar. And thank you to Jennifer for the warm welcome from you and your staff.
Thank you, Cindy.
Thank you. I just wanted to say one thing before I forget that, and I really want to you know, acknowledge the work of the Waututh and Logic, all of that good work and the research from the Caring Society, and we have the First Nations Witness. When you go on that site, you'll see all those information sheets. We also have the Our Children Our Way Society. If you go on the site, you can see there's a jurisdictional toolkit, and there's a jurisdictional toolkit 2.0. And it's really all the information that, well, not all the information, but to really access all these resources before you start retaining a lawyer. I know I've heard this across, there's a lot of lawyers that are coming out of the woodwork that are all of a sudden, they may have been in corporate law, but now are child welfare experts. And so, you know, take the time to look at the resources that are there free of charge. There's a lot of good resource people that you could talk to really start to, you know, when you start thinking about going down the jurisdiction pathway.
Thank you, Mary. So we've had a series of questions that have come in advance, and so wondering if we might be able to shift to some of those questions. Also see that there are a number of questions coming in through the Q&A function on Zoom. I don't know what would be helpful, Cindy, Naiomi, and Mary, if you want me to read them out. They're displayed there on the screen. If you just want to move forward with responding, what would be helpful?
I think it's good everyone can see it on the screen. We can maybe spend time on the answer. And I think this one is Naomi's.
Okay, great. I'm sorry, I was just writing some responses to somebody else in the chat on some of their questions. Okay. Oh, yes, I read this one earlier about a statement of the sovereignty of their nation. The source said that when they went to see if they could use the provincial court for dispute resolution matters, this is a nation, Alberta, pertaining to CFS, the province declined because they said the FN already had the right to conduct their own dispute resolutions via the Constitution Act. Please explain this a little more. So I think, so some of this, I think, to me strikes me as a little odd. The Act does, so C-92 does recognize that jurisdiction includes the right to create our own dispute resolution mechanisms, and some communities have started to develop through their own laws, their own ways, instead of taking it to provincial court or some other court system to have that done. And I have heard that, particularly in Alberta is taking a very strange sort of position that, you know, they're almost sort of like, oh, you're going C-92, well, you have the province has no obligations to you, or a little bit like that. I don't know the full thing. I'm here on the other side of the country, but this act does not mean that the provinces can just kind of wipe their hands. Quite the opposite. It should, you know, in accordance with Jordan's principle, in accordance with, you know, the court talks about a braiding of different jurisdictions together. The province and the feds continue to have obligations, and they should have obligations. And so, you know, and you can structure your act the way that works best for you, so that if you're not ready to assume or create a court or a tribunal to hear things, you should be able to continue to take them to the courts if that's how you want to structure it. If you want to start looking at and developing your own tribunal, that you should be able to do that too. So it's not that, you know, one way cuts off your mechanisms. And you know, positions of provinces who are trying to say, oh, well, we wipe our hands of this. I don't think that can happen either. And so some of this stuff, if they're taking positions like that, means we may continue to have to fight. We may continue to have to challenge. It may look like human rights. It may look like more Section 35 challenges. We hope that governments will come to their senses and not, you know, make us take those approaches. But these are things that, you know, we will. It's not the work will continue. The advocacy will continue, and that's sort of part of all of this. Cindy, I don't know if you wanted to add to that.
That's good.
Question there for you.
Yeah, one of the things I'd really recommend everyone read is the report by the Assembly of Seven Generations, which is called Accountability in Our Lifetime. That really talks about this, and Mary referred to it earlier, where we have you have this important work happening, but it's important to have that accountability, that mutual accountability going back to children and to families. So look at how they define accountability in that report. I find it really, really a very helpful kind of guide. And then also look at Naiomi's work on her report on Jordan's Principle, which I'll put into the chat. So both of those things together, I think, are really helpful in understanding how we hold different actors who are interacting with children and families accountable for their work over time.
Next one, you get a 3-part question.
I can answer that. So with MCFD, there are policies around when there is a child losing their life, you know, to provide the supports to and in this place, I guess would say the key caregiver, the key parent. It's just, you know, the child death, everybody's knows what's going on, but within MCFD, it is, I think there are limitations to who is considered family and what cover costs they can cover. For us as an agency, you know, we understand, like, you know, we've at our agency, we've only had the one death, but definitely we covered all of those cultural traditional pieces. And again, you know, the family, you understand, it's not just the primary parent, but there's also auntie that's involved. So definitely there is a process that MCFD does have policies around what that looks like. The resources, of course, are available for children aging out of care. It's different between provincial and, of course, federal. So right now there is post-majority supports at actual cost if you're a federally funded former child in care. But if you were a child that was removed off reserve and you're considered provincially fundable, there is some supports for post-majority in British Columbia, but not the near extent as the actual cost. So there are limitations and there are differences both. And so there are some, again, at our Children Our Way Society, if you go onto the site, there is information around on post-majority on that. And also there is some information for the provincial funded post-majority on the MCFD site. Any recommendations on family supports and building alliances with safety planning? One of the things, again, I would say is if you go to our Children Our Way Society, there are different supports there, but I think it's really important. There's also lots of good, if you go to the First Nations Caring Society portal and you look at all the research, there's also some research and some really valuable takeaways from that site. But I think for us, when we're looking at the family supports, you know, there's good family support workers within the agencies. And I don't know if you're part of an agency, but definitely what always is the best thing is to have those initial meetings even before the child is removed to prevent the child from being removed. So that's how you identify the family supports. In fact, in our jurisdictional framework at Sekani Family Services, that is a key role. That is number one role. We actually have a community wellness team that comes together and identifies those issues which could cause the children from being removed and come together and provide not only a family support, but a community support around that family, or to deal with those broader issues that perhaps could cause children going into care.
I'll take a first step, but I think we've tried to sort of get at some of these questions in the presentation too, which is, you know, you can take off, you can address parts of this, right? You can assert jurisdiction on an incremental basis. And so, you know, you could say, what are the things that are the most problematic in terms of the provincial child welfare system, and how, you know, communities can assert jurisdiction to you know, address the aspects that are you know, the worst in terms of how they see it. So you could do things like develop a definition of best interest of the Indigenous child. It will have to still be consistent with the definition in C-92, but it can be that and more. Like, so there are ways that you can do that in documenting best practices. I think Mary spoke to that. So there's definitely, you can take on smaller pieces and do exactly that. And some of the work, I think, on sort of looking at our stories and our language and what they teach us about taking care of children and our responsibilities is another great piece that the communities could start doing.
I think the other thing too is really looking at right now how you're changing practice so that when you're assuming the laws and you're upholding your laws later down the road, that you're actually, there would be no child to fall through the cracks. So there is a current state that you're in right now. You have to look at that transitional state to get to that future state, having your own laws. Is my puppy again. But I think the other thing too is ensuring that your matriarchs, how you made decisions, and getting those bodies really active and involved in decision making right now.
Another two-part question.
Okay, I'm just going to read them because we'll all know them. So, is there any legal risk to a First Nation with giving notice as an Indigenous governing body status for the purpose of notification under Section 12? Like, I don't think that they should. So I'm not totally sure. And how are their rights and responsibilities as an IGB different after giving notice under Section 21 and 22 of the Coordination Agreement? I don't think that, you know, the fact of, until you have your law in place, I believe that, you know, notice should still be, and it's, you know, other provinces will have an obligation to give notice, essentially, you know, that these are national standards, they will always apply. So it should not affect in the giving notice, you know, if there is a case, whether it's in your province or the neighboring province or wherever, that involves a child from your community, there should still be giving notice. And if you have your own laws, that might then involve you in a conversation with them about how those two interact. So I don't think it should affect the ongoing obligation of provinces to give you any notice of any hearings that are going on that are involving your children in your community, outside your community, and outside the province even. I don't know if you guys wanted to jump in on any of that part.
Yeah, I think I think the question here, and I've been asked this before. So if you look at what's happening, say like you know, Raymond Schulich is, for example, his agency is considered an Indigenous governing body. Sekani Family Services is considered, saying that we are an Indigenous governing body, because right now within the Act, you know, there's a notice of significant measures, and in the provinces, at least here in British Columbia, you have a repository of where the information has to go. So if there's a child that is down, outside of Caris County territory, and there's something happening to that child, there's a legal obligation to tell the nation of the significant measure, but they also have to tell us as well. Again, understanding that sometimes in the communities, staffing changes, capacity, all of these issues, so that we'll all know, we'll be on the same page to provide the best wraparound services for that child based on that significant issue that they're dealing with.
So we have one more question that sort of came in advance, and then once we move through this, we can make our way over to the questions that are coming in through the Q&A function. Naiomi, I'm happy to read it out for everyone if that's the preference here. I wanted to share there is concern over the type of population measures being used to inform IFSD's studies, whether for prevention programming, Jordan's principle, and substantive equality research, and also, more importantly, the final settlement agreement. IFSD is using StatsCan data from 2021, in addition to Indian Registration Administrators data, where margins of error in community populations vary between 2% at the lowest and 28% at the highest within 7 of the communities our agency serves. Is there any discussion around this? Is there any concern about the validity of the research being conducted, knowing that such discrepancies exist?
Well, if I'm right, I think we have Helena Gaspard on the call, and I don't want to put her on the spot, but she may want to, first of all, just respond to that very important point. I would say, you know, there's been a lot of discussion about population basis data. If you look at IFSD phase 2, it's based on the population actually served in that particular community. I don't know if Helena's still with us. She was earlier. Just looking in the scroll.
Yeah, she seems to be there.
We may not be able to move her
Oh,
over.
I am. I think.
Oh, there we go. Oh, perfect.
Yes, I think your colleagues kindly have me join as a panelist. But I can't seem to turn my camera off, but Carolyn, thank you very much for the question. And I appreciate the opportunity to talk about this. And part of IFSD's challenge in doing this work is actually having access to consistent population data. So one of the things we've tried to be very clear about in building out these cost estimates for analysis is that we do need some common basis to generate national estimates. In the past, we've actually asked service providers to share the size of their population served. And you'll see in past reports that we actually run those estimates using different population sources for the very reasons that you highlight, because there is no fully or completely reliable population assessment for First Nations in Canada. That's certainly a problem, but one that we have had to overcome for the purposes of cost estimation and analysis. And so when we're running our analysis, we are using IRS data specifically on reserve for any national estimates. We do leverage Statistics Canada or census data wherever required or wherever we can, especially when it comes to assessing things like the quality of the housing stock or even median household incomes, because that is the only source of data that exists consistently. Even if it's imperfect, it is one of the only sources that exist. So we are very, very happy to provide alternative estimates or to be able to generate the estimates with better data if that data is available. But again, where we sit, part of our mandate is actually to generate national estimates. And one of the only ways that we can do that consistently is with nationally available sets of information. So I hope that's helpful, but it's a very good question and certainly one that we continue to struggle with.
Thanks, Helena. Sorry to put you on the spot, but I thought we might as well take advantage of having you right here to answer that question.
Thank you, Helena. It's good to see you. So gonna make our way over now to the Q&A function, and I see there's been lots of action going on behind the scenes and lots of questions getting answered. I'm gonna head over to the questions that remain open and just bring them forward in the order in which they were received. So the first question is from Lenore Baker, and it says, what is the plan to support First Nations workers, such as roots practitioners who work for CF agencies bound by their policies, oaths, practices, as they interpret job descriptions from a colonial lens? To best service off-reserve families, how do we as workers be protected to deliver services? Also, all internal systems do not support us. Unions, EI, LTD, WorkSafe, etc. None of these systems have First Nations practices that support workers suffering with systemic impacts, lateral violence, etc.
I'm going to just take a stab at some of the important point about all frontline staff, in my view, need support to deal with the trauma that we're interfacing with on a regular basis. I did line work myself for 13 years. Deb has done it. Mary's done it. You know, it does take a piece of you because we're dealing with children and we're dealing with families and a lot of crises. So one of the things that Mary and I were just talking about today is I really recommend everybody take a look at the work of Cheryl Regur. I'll put her name in the chat. But she's done a lot of work on trauma and first responders. And somehow those of us working with children and families aren't always included in those conversations. You know, we think about fire, police, and EMT professionals and others, but we really need to broaden the conversation to include people on those front lines. And Deb, you have been so thoughtful about this over the years in terms of wellness and everything else. I'm wondering if you have a few words to share.
Thank you. Yeah, it's been my lifelong work, as you know, as everyone here. I think it's, yeah, really important. I know we talk about, you know, how capacity and we all know, I like the idea of having the discussion about trauma for frontline workers, because we know that it is a difficult work and it's hard to recruit, retain our workers through all of this for child and family. And yeah, I agree that and we talk, you know, we're talking about trauma informed services, and but yeah, we need to ensure that the caregivers or the ones that are in the lead of this work are also being supported, because we know that you can't do this work by yourself. You can't do this work when you are having your own triggered issues, whether it's within personally or with your families or in your communities. So yeah, I really agree with that. And it's, as I said, it's not an easy job, but we all have, I think we just have, as I said, and many of you, is that this is heart work. And if we lead with our hearts, then you know, all we can do is do our best. And also, you know, as matriarchs, mothers and aunties and grandmothers, this is our ultimate responsibility, is the care and protection and showing our kids love to do this work. Thank you.
Thank you. And I think I'll just speak to this. It's coming from the child and family agencies, and more specifically in British Columbia. I definitely understand it and really hear the again and again from our social workers, our frontline workers, our youth workers in the midst of this opioid crisis, how much hurt that you know that we carry, especially as Indigenous people, because it's our children, it's our, we know we're seeing them die on the street and all of the all of that. But I know most of our agencies that we do have the supports that, you know, most agents have the you know, the cultural a cultural elder person that's there. Our policies for the most part support that supporting the frontline workers. You know, we have like extra days off for cultural activities. We have extra days off for self-care. So there's things that we can do within our own policies that we made changes. Keep in mind as well, though, that British Columbia just started receiving prevention funding 2018, 2019. And it's only been since then that we've actually been able to be on par with MCFD as to what we could pay for them. So a lot of those resources weren't there to provide the ongoing support. So agencies, and I really feel for the nations that weren't part of an agency. You know, we really have to build that capacity to ensure that our workers are taken care of, and that is in many of our policies and in how we practice. You know, we do have, for example, with our agency, you know, we do have that. We always have the mental health practitioner there for our staff. We have additional days off for self-care. We have additional days off for that cultural practices. So it's really important that we look at that, because, you know, whatever recommendation you as frontline workers, you know, to provide that to your leadership to say, this is what we need. There's also that personal responsibility. And I know, and I say this to my workers again and again and again, ensure that when you're feeling burnt out, that you just stop and take the time. But so many of our people that are in this giving field give over and above, and I'm always saying it's okay to take a day off. Those problems will be there tomorrow, but you have to be really cognizant. I'm one to talk, but you know, we have to really be aware of how much we can take in this work.
Thank you, Mary, and thank you, Deb, and Cindy. I think what you have shared, most of us can appreciate in this conversation. So thank you for that. Next question we're going to go to is from an anonymous attendee, and it says, do you see a role for non-government agencies in the support of First Nations communities and their commitments to self-governance and the care of children and families? If so, what are some of the contractual implications anticipated, particularly around who ultimately has decision-making authority on behalf of the nation? Also, there are some concerns being expressed recently around the challenges that nations are having to establish sufficient liability coverage in support of these activities.
Well, I'll take a crack at the liability one, and just to say that we want to acknowledge our colleagues at the National Advisory Committee, because we've been studying some of these questions. There are liability questions that people need to be aware of. And what we're finding is, first of all, the more vulnerable the population that you're serving, i.e. children, the higher the liability. The more vulnerable those children are in terms of risk, the higher the liability. The more control you have over what happens for those children and families, the more you are liable. So in all those boxes, you think about child and family, then you tick all those boxes. So that puts you in the high liability category right there. And what I always encourage people to think about is not just, think about liability for the organization, of course, and for the nation, but think about the employees. Think about folks like foster carers or elder advisors or youth advisors. So think about everybody in that circle and how you would ensure that if a liability claim came against them as an individual or as the individual in the organization, that they're protected against having to pay for the litigation costs out of pocket, because you could have a claim that doesn't succeed, but you've had to defend it all this time, and also the eventual judgment. And we're finding with the insurance industry, thanks to these decisions, is that very few insurers will insure against abuse anymore. That's not due to us as First Nations, but it's due to some of these big judgments like the sexual abuse scandal in the Boy Scouts of America or among the churches. The insurance industry, given climate change, is much more risk averse than it used to be. And so the prediction is within the next 7 years, you won't be able to get any insurance against abuse. So these are important questions to look at. And I always say, in this, and going back to Mary's point about there's a fine line between jurisdiction and offloading, I feel that the government of Canada needs to step up to the plate and be the insurer of last resort. Because often they'll say, well, we'll pay your premiums, but that assumes that you can get insurance, first of all. And second of all, that insurance is adequate to protect everybody that we talked about that would be in the circle. So think about mapping out all the people who are going to be a part of the circle of care for the children, who might need potential liability protection. Talk to your insurers and keep them up to date on any of the practice decisions. This is even for those of you who aren't under jurisdiction. If you launch a new program mid-year after you insured your policy, get back to your insurer and say, hey, look, we put out this new program, just so that they're aware and you can be assured that that'll be covered in your piece. Talk to skilled liability lawyers, tort lawyers, and get advice from them about your unique circumstances. Naiomi, do you have anything else to say about that?
Nope. I think you've covered it, and it's unfortunately it's not specifically an area that I've come across too, but I know that my friends at different negotiation tables who are there as lawyers are talking about it with their clients. Mary might have some. I see her. Yeah.
I think oh God, this insurance. I say this. I know too much about insurance, things I never wanted to know, just because of this issue that has come up in British Columbia, where the province was saying they were no longer going to insure us, but we do have insurance existing right now. But to be really cautious, like when you are going to you're going to be establishing your own laws, and I'm talking about the current state, the transition state. If you're a nation that is right now in BC, that you are covered by the delegated agency that you are covered by the province if you're a nation that is being served by a delegated agency. If you're a nation on its own without without being part of a delegated agency or unaffiliated, you have your own liability insurance, and you don't get funded to do that adequately. So to be very cautious. One of the things that I think, Cindy, that we perhaps need to do again is to do that liability webinar, the risk webinar. I know with Corin, she does such a good job. David, like, you know, we have really good people, because there's ways that you can mitigate the risk. And so, you know, in absence of having the proper insurance, or like insurance that there's so many gaps in insurance, there are things that you can do to absolutely mitigate the risk. And simple things like, you know, ensuring your policies are up to date, making sure that the practice, like accountability, evaluation, all of these things, identifying the actual role that you're going to be playing. What are you going to do? And are you insured for that? For example, if you're going to take up midwifery, are you insured for that? Like, there's certain things that you can do to actually reduce your risk. So I think we should do a webinar on that, Cindy. The second part of your question, like, do you see a role for non-government agencies in the support of First Nations communities and their commitments to self-governance? I do see a role. I don't know if they're a government, but I think if you think about one of the things, I think what you really should be working at when you're doing jurisdiction, first and foremost, is to build trust in your community. That is number one. Ask your staff, ask yourselves, like, how are we building trust? Because what you want is the most vulnerable of your members to come forward to the agency or to the service provider to say, listen, I need help. I need help. And you need to make sure that trust, so then you want to make sure that there's no political interference, so that there is that trust. And so one of the ways that I was considering this, or I've been thinking about it within our jurisdictional framework, we do have the representative child and youth who has developed trust with our people. It's an unbiased place, you know, people, the youth, they just represent the youth. So there perhaps is a role for like a representative children or youth, or the advocate office outside of your own laws, but you could embed in laws that what that relationship would look like. I'm thinking of some of the roles of the public guardian and trustee, right? There could be a role for them within that. So there are really, like, who is it that you need to ensure that there's that trust within your nation, within the service providers, and within your own laws? I think that's what we need to ask ourselves.
Thank you, Mary. And thank you, Cindy and Naiomi. Just recognizing the time, we've quickly arrived at 12 p.m. Pacific time. And so recognizing that there are still questions in the Q&A function that haven't been answered. I see Naiomi is frantically typing to respond to one, and several of those questions have already been answered. We will continue to track those questions and bring them forward to future conversations. We will ensure that this recording, the slides, and the questions that have been answered online are available through our website. And so apologize to those of you who have submitted questions that may not have been answered, but also want to honor everyone's time today. And so with that, just really want to raise my hands to you, Mary, to you, Cindy, and to you, Naiomi, for all of your brilliance, for the wonderful presentation today, and to everyone who is here listening and learning, and with all the questions that have been brought forward. I'm going to turn it back over to our elder, Deb Foxcroft, and ask if you could kindly close us in a good way.
Thank you. Just really very inspiring today. Just want to acknowledge all of our panel, Cindy, Naiomi, and Mary, just sharing their wisdom and their brilliant minds and such compassion and dedication to do this work on behalf of our children, youth, and families. Very inspiring. So I hold up my hands to you all. And I was just thinking it would be so great if we could just gather all this collective positive energy and love for our children and families, so that we all can move forward in a good way, and that we come with our open minds and hearts, and acknowledge everyone that's in this field of caring for our children, whether it's grandmothers, matriarchs, aunties, uncles, grandparents. We know that that's one of our elders said our most ultimate law is the protection of our children. And that was the late Alice Paul from Sďwməthkվəy, in one of our elders in our communities. And I just need to just thank everyone for being here and for the tremendous work that you do every day. Whether it's in your communities, whether it's in your agencies, whether it's as parents and as grandparents, we all know we have a responsibility for our children and our youth, and that is a sacred responsibility that we all carry. So I just wanted to just a reminder that our children and our youth are watching us, and they're waiting for us, whether it's today, tomorrow, or in the future. And so I just wanted to remind us, and I think a lot of our presenters said, we need to be able to ensure that we are the voice for our children and youth, and that we carry that sacred responsibility forward. I know that it takes a lot of strength and courage, and so much love and compassion and dedication to do this work. And so I just wanted to hold up my hands to everyone and honor you on the pathway forward on your journey. But it takes all of us to be able to do this work in a good way. So I just wanted to just say Sďwx Sďwməthkվəy from Sishat territory, New Chonmouth territory. And I ask that you have safe travels, and wherever you're going, and look after yourself. Just sending much love and strength and healing to you all as we continue doing this work. Sďwx.
Wonderful. Thank you, Deb. Wishing each of you a wonderful rest of your Friday afternoon for us here in British Columbia, and just that gentle reminder about the Loving Justice conference that will happen out here in British Columbia from September 9th to the 11th, where all of these amazing conversations will continue to unfold. Take really good care, and thank you so much again for your time today.
Thank you. Bye-bye. Yes, I did, Kai. I took many photographs there. Good on you. It was wonderful. Take care.
Awesome. Thanks, Michelle.
Yeah,
Thanks
that was
for joining.
great. Good on you, my dear. Have a good weekend.
You as well. Take care.
Okay. Bye.